Good morning. So as Kelly said, I'm Arly Smith-Pearson.
And I am Szmulowicz.
You will be tested on the pronunciation of Larry's last name at the end. That's one of the pop-up questions. And we're going to be focusing on digital evidence, electronic evidence in family law cases today. Generally, we're going to be talking about text messages, social media, and voicemails. I want to encourage you to ask questions throughout the presentation and not save them for the end. Please send anything in that you've been waiting to discuss, and we may not know the answer, but we can at least, talk about what we think about the questions. And let me see if I can work this. Great. So when dealing with electronic evidence, the #1 rule that you want to remember is to preserve the evidence as soon as possible and make backup copies. I believe that anyone, no matter how long or how short of a time they've been practicing, has had a client whose phone was dropped in water, the screen cracked, they lost their phone, their carrier turned off their service. Any number of things happen quite often where people are going to lose their electronic data. So it's very important to make sure that as soon as the client contacts you, get that electronic evidence. And try and get it multiple times in multiple forms because we all know how trials work out. And sometimes it's good to just have a backup plan. I have to use my mouse instead of my keypad to change the thing. So how do you preserve this electronic evidence? For text messages, and this applies to text messages on someone's phone, it applies to social media messaging apps like Facebook Messenger, Instagram direct messages, WhatsApp, emails, really any way that people are communicating directly through a written form. There's a couple things that you want to look out for when you are preserving this evidence to use in court. The best way to preserve text messages is getting a screenshot directly from the client's phone. Sometimes a client is not able to do that. They don't understand how. Their phone or their computer doesn't have that capability. And the next best thing to do is take another phone and take an actual photograph of the client's phone with the message displayed. What's important is what is going to be in that text message and the photograph. You want to make sure that you get the entire content, that you get the date and time that the message was received, and you get the telephone or the sender's information. To go into those things a little more in depth, for the content, you want to make sure that you get the entire message and the entire conversation. So, when you are speaking with your client and they send you just one screenshot, you want to have a conversation with them. What's on either side of that conversation? Ask for their consent. If you can look and see what else is in that conversation and whether you think it's important to have. And it's also important to have a frank conversation with your client and ask if they deleted any messages. Sometimes a client will delete things that they sent that they believe are unflattering or hurt their case, things like that. And you want to make sure that you know what's missing to prepare for that when you come to court and your opposing party pulls out their phone and there's a string of conversations that you weren't prepared for. So if your client has, they tell you, yes, I did delete part of the conversation. There are apps that you can use generally for a fee that can download entire message histories, even if the message has been deleted. In addition to getting the entire content of the message, you're generally going to need more than one screenshot, and it's going to be a multiple page photograph or document. When you're taking those screenshots, you're going to want to try and overlap the conversation so that you have a little piece of the previous page on the second page. So that you can imagine if you print out all of these pages and you go to the printer in your office and somebody had dumped them all on the floor, you would be able to put them back together even though they've been put out of order. So you wanted to make it easy to be able to know what part of the conversation is where. For capturing the time and date that the message was received, if you are following the first rule of preserving evidence early and often, you may have a client who comes in shortly after a communication, and if they take the screenshot that day, the date and time will display on their phone as today or yesterday. I would encourage you to still get that text message that day they come in, because it's better to have it saying today than nothing. But then the next time they come in, try and take a second screenshot where it displays an actual date instead of today or yesterday. Generally on the phones, you have to wait a couple days to where it displays the actual date. And then finally, you want to make sure that you capture the sender's information. Often in our phones, on like on social media, things like that, people are going to use nicknames. Sometimes they're unflattering, especially if you're doing this in some sort of custody situation. I've had a client who had her child's father in her phone as sperm donor. So there's two issues when you have an unflattering contact information. One is what we're going to talk about, authentication and authorship, which we'll get to later. For that issue, you're going to want to take a screenshot showing the communication, and it'll say from sperm donor. But then you're going to want to go into the client's phone or into the social media profile page to show the contact information for sperm donor, right? So you show that the name given in the phone is an unflattering name, but it's connected to this phone number. Or, they use a nickname on their social media account, but it's connected to this profile. Same with an email. Sometimes it just comes up with a name, but you want to go and capture that email address. The other issue beyond authentication, which we're going to get a little more into, is that there's the ethical issue of changing it. If you're going to go into a custody case and there's an unflattering name for the child's father, you may be concerned about how that's going to appear to the judge. So have you ever thought about asking the client to change the phone number's contact name in their phone and then taking screenshots? I know I've wanted to. Larry, what do you think about that?
Well, because the ultimate question in the authentication of these messages is whether this is a fair and accurate representation of the message that they received, right, at that time. I don't think the client can honestly say yes to that question if they have altered the contact name. So I think if they do change it, then at some point in your direct to the client, like it's going to come out that they changed the contact name. I would feel ethically obliged to make sure that that information came out. So that would then ultimately defeat the whole purpose of changing it in the first place. I think that it is what it is. You're stuck with that unflattering nickname, and we'll have to maybe have the client explain a little bit about why they entered the nickname the way they did to try to mitigate that damage.
Exactly. So you have gotten your electronic evidence. That's great. You have it ready to go to court. How are you going to get it into evidence? For the actual screenshots, the photos that you're bringing into the courtroom, it's pretty basic. You're going to lay a foundation as you would for any photograph, where you're going to have the client, you know, describe what it is. And then the ultimate question, is this a fair and accurate representation of the message that you received on X dates? But the issue is a little more complicated when we get to the question of authorship and authentication of the actual communication contained in the photograph. So authorship, who sent that text message, is a question of authentication under Pennsylvania Rule of Evidence 901. 901 has a pretty low standard for admitting evidence. Generally, it's just that the proponent demonstrates that the item is what they claim it is. And in the situation of electronic communications, here you are the proponent, and really what you're saying is you're offering this communication, this message, as having been written and sent by person X. How do you show that it was written and sent by person X? So there is some case law on this, starting in 2005 with In the Interest of FP. The court discussed electronic evidence in general, finding that it's not inherently more unreliable than non-electronic evidence, and that the most important holding in this is that 901 applies to electronic evidence, and that circumstantial evidence of authorship can be sufficient to authenticate. So what types of circumstantial evidence are enough? In Commonwealth versus Koch and Commonwealth versus Mangle, we get two cases showing us what's not enough. And I think it's important when you read these cases to read them with the lens that it is a criminal prosecution. And in family law cases, we often have it a little easier than a prosecutor because generally our parties know each other. So in Commonwealth versus Koch, we're talking about text messages. And here the court found that where the defendant owned a cell phone, and they could prove he owned the cell phone, but not that he sent the messages or he wrote the messages, that's not sufficient. Just ownership of a device is insufficient circumstantial evidence to prove authorship and authentication. And then similarly in Commonwealth versus Mangle, we have Facebook messages. Here, a detective found a social media account, a Facebook account that belonged to a particular person, and the account had his same name, his hometown, his high school, but the court said that the messages sent from that Facebook account, there wasn't enough evidence to show that this defendant sent the messages on that Facebook account. So these cases would make it seem like authentication is actually a pretty high bar, but I would argue that they don't. That in family law cases where the parties know each other, they set out kind of circumstantial evidence that you really just have to identify the person who's sending the message. And luckily, the court has caught on and decided to codify some of this case law and give a little more guidance to practitioners about how to deal with this question of authentication. And so it was recently announced that the Rule 901 is being amended. And effective October 1st, 2020, there's going to be a new subsection to 901. The new subsection is 901B11, and it is specifically dealing with digital evidence. And the court has said that to connect digital evidence to a person, You can use direct evidence, such as testimony of a person with knowledge, or circumstantial evidence, such as identifying content, or proof of ownership, possession, control, or access to a device or account at the time when corroborated by circumstances indicating authorship. And the comments to the rule or the amendment to the rule are very helpful, and they really, you can see some of this case law just being codified into the comments. So it defines digital evidence in a broad sense, so really any communication, statement, or image existing in electronic medium. So that's going to include emails, text messages, social media, things like that. This is an important thing that I think some judges often get confused about, but the comments make clear that the proponent of the digital evidence is not required that no one else could have been the author. And so you do not have to disprove that the neighbor didn't come into the house while your client was taking a shower and send this message, right? You just have to show that more likely than not, person X authored this text message. You don't have to eliminate the entire universe of other people who could have authored it. And then they give examples of what direct evidence can be. It could be the opposing party admitting that they made this statement, or possibly a third-party witness who observed the opposing party send the message. And then examples of circumstantial evidence are identifying content, such as self-identification, distinctive characteristics, and then circumstantial evidence, and then they do highlight that possession alone of the device is insufficient. And that's your Commonwealth versus Koch holding, that you have to have possession of the device plus some indication of authorship.
Just to be clear, the other example there, I made that up under direct evidence. I was just trying to think of some other example of direct evidence. It's not actually in the comments.
Oh, thank you.
Sure.
But it's a good example.
Thanks.
So what does this look like in practice? What I like to do is work it out with my client. When the client comes in and they have these text messages, we go through them, and human beings do this naturally. Like, we receive digital information and we are able to process the information that we receive and know where it comes from. The hard part is verbalizing what we do naturally. And so I will talk to my client, and in cases where they have received communications via, they've been spoofed or they've used blocked numbers, things like that, I will ask them directly, how do you know it was the opposing party? And they generally will be able to say something, but if they're having a hard time verbalizing how they knew who it was, I will often ask the reverse. How do you know somebody didn't steal his phone and send this text message to you? How do you know it wasn't someone else? And when framed in that way, your client is often going to have that golden nugget that will just hook your authentication for you. Like, oh, he used this nickname, or he's spoken half Creole, half English, which is how he always talks. So use your clients to get you to the authentication. Don't try and come up with this by yourself. But examples of things that will help you authenticate this digital evidence is the names on the account. If there's a profile picture attached to the account, you can use more than just the conversation that you're trying to get in. Maybe 3 days before the threatening text message, there was a text message that self-identifies. And a self-identification is often where a person will, identify themselves through a relationship, like my son, my uncle, or they will identify themselves through a event that we know happened. Like Why'd you call the cops on me yesterday? Or, you know, what were we doing at the McDonald's when you know, X, Y, and Z. So things like identifying themselves through events or relationships to other persons are often very good ways to connect the message and the sender to your defendant. These kind of your golden ticket parts of the message are sometimes going to be a little farther back or forward in the message history, which is what I like to go over with my client before you get in there and say, how are we going to connect it? Can I look through some of the conversation a little before and a little after? Larry, do you have any other examples of tying a conversation to a person?
Yeah, I mean, the one that comes to mind, there was a case where the messages were sort of the crux of the case. I think it was a PFA matter. So there were these threats that I think were coming through sort of old-fashioned SMS text messages. And we did exactly what you said. We went back into the history of those text messages, and the golden ticket, the metaphor you were using, were photographs that the opposing party had taken of a deceased relative. So you took a photograph of this deceased relative and sent it to the client. So, you know, you're with that past history of messaging, we've already substantially narrowed down the universe of possible authors here. Yeah, I mean, that's obviously great evidence of authorship, and was certainly enough to get us over the authentication hurdle.
And then one thing that I wanted to highlight before I turn it over to Larry is I have had some judges in PFA cases push back against my reliance on Commonwealth versus Koch and Mangle. And they're saying that those are criminal cases. They're not helpful in family law cases or civil cases. And I just want to highlight that a Superior Court opinion expressing and expounding on the rules of evidence is applicable in both civil and criminal. The rules of evidence apply the same in civil and criminal. So those cases, if you get pushback, really do apply, and they deserve the same weight for their propositions in a civil case as they do in a criminal case.
If I could just interrupt here, this is Kelly. I'm going to launch the first of the CLE polls. If you can just respond yes or no, attorneys, this will be available for 1 minute. And please feel free to go on with the presentation. Thank you.
Sure. So this is where I take over, Arly?
Yep.
Okay. So voicemails. I feel like this is like becoming less and less of a thing, but still, you may at some point have an important voicemail that you want to enter into evidence. So how to preserve? This can actually be a little bit tricky. If we're just talking about quality of the voicemail itself, then some phones are able to export that voicemail as an audio file, right? And that's you know, that's going to get you the best audio quality. As Arly was saying, number one rule: preserve early and often. You know, I would recommend, if that is an option, to use it, even if that's not ultimately the thing that you end up, you know, playing for the court, because at least you have that backup in case something does go wrong. The issue is that you still are going to need to link that voicemail to you know, the date and time that it was received, and the audio file, more likely than not, is not going to give you that information. So another way of preserving a voicemail is a little bit maybe inelegant, but it would be to simply play the message on the receiving device, most likely your client's phone, put it on speakerphone, and then you use a different device to record it. So that that may solve your issue depending on whether or not whether the phone will read out loud, so to speak, the envelope information, meaning the date and time of receipt. But some devices nowadays don't do that. Actually, I don't have an iPhone anymore, but I don't think the iPhone can do that, right? It'll show visually sort of the entry for the voicemail and have the date and time, but there's no way to actually get the device to say, again, out loud, the date and time that you could capture in audio recording. So the way that I get around that hurdle is simply to just not to use a pure audio recording, but to actually make a video recording. So it's the client's phone and your client's finger, you know, coming into the screen and pressing that particular entry, showing the date and time that the message will be received, and then it plays, and you've captured now both the visual of the date and time that the message was received, plus the audio. You know, this is important for a lot of different reasons. I know lots of judges who actually will reject voicemails or other kinds of electronic evidence if it isn't linked to a particular date and time. I don't know if you have those kinds of judges in your jurisdiction, but if you do, then it's obviously very important. But also it may have a lot of just legal significance, right? So if you're trying to show that you know, the opposing party violated a protection from abuse order, then obviously it's going to be important whether or not that message was received after the order went into effect. So yeah, that's one you know, relatively simple way of recording or preserving the voicemail in a way that you'll be able to then authenticate it at court. Yeah, and I actually did have, I learned this the hard way. There was an example where I think it was an iPhone. I had the audio on one hand and then screenshots of the voicemail entries on the client's phone, and opposing counsel did a good job of trying to attack the connection between those two things, and I actually ended up having to call the paralegal into the case as a witness to show that, you know, which of those voicemail entries connected to the audio. And after that, I learned my lesson, and it was videos from there on out. Okay, we can move on to the next screen.
I want to read a comment. There's
Sure.
a comment that they suggest having a police officer write a report with the date, time, and caller information of the voicemail. What do you think of that?
If you have, yeah, I mean, that could potentially work. I think that in Philadelphia, it would be difficult. I mean, if you're talking about maybe a detective would have the time and inclination to sit down and transcribe a message. But then you are going to have the additional problem that you're going to actually have to call that person into court, most likely to admit the report into evidence. So that's pretty laborious way of doing it for you know, just based off of our practice or my practice here in Philadelphia. But I suppose that would be a way of solving the issue as well.
That suggestion came from Bucks County. And we also have a chat that I guess they don't indicate what county this one is in, but they have been granted, like Lycoming County, they've been granted permission by judges to bring the client's cell phone in as evidence if it's a voicemail being used.
Yes. I think in a pinch that can definitely suffice. Again, in Philadelphia, my experience has been that most judges, they want to, they like to have something to put into the file. So, you know, in the example of a video recording, I would be actually storing that video recording onto something like either a CD or a thumb drive, something like that. But yes, I mean, in a pinch, I think you can just pass the client's phone up to the judge, or everybody crowds around, I guess, the judge, and then somebody presses the, maybe have the client then press the appropriate voice message, and then play it for the court, and then hope, it would be captured by the court's digital recording equipment.
I do think that I agree with Larry. That is possible in a pinch, but you also want to think about if you're going to have to appeal. That's not going to make a great appellate record.
Good point. Yeah. Okay, so voluminous telephone calls and text messages. So this is sort of a scenario where it may not be so much the content of, for example, like, the SMS text messages or the calls themselves. It's just that it's this sort of barrage of calls and text messages that you may be using to establish a pattern or course of conduct constituting stalking. So I think the best way to present this kind of evidence would be to subpoena the telephone carrier for what is generally referred to as the call detail or text detail. So I don't know if people have seen one of these before, but it sometimes actually will come in the format of an Excel spreadsheet or a similar type of chart. It's fairly bare bones. You're getting the date and time of receipt, when the call was made, when the text message was sent and received, the receiving number, which is going to be more likely than not your client's telephone number, sending number, probably the opposing party, and if we're talking about calls, then the duration of the call. It's important to note that you are not going to be getting the content of text messages through a text detail. It is just the bare bones sort of data that I just mentioned. And another little note would be when you're subpoenaing these kinds of records to definitely ask for a letter of self-authentication. That way you don't run into the issue of having to try to subpoena somebody from the telephone carrier to actually appear in person, or virtually nowadays, as a custodian of record. So that would be sort of the best way of trying to preserve and present that information to the court. The next best would be to go back to the screenshot / photo method, going into the call log or the text message log on the client's device and just taking lots and lots of screenshots. But that can be a bit burdensome, maybe a little bit difficult to present in court. So if you can get the call detail or text detail, then I think that is the preferable way of going about it. Thanks, Arly. Something to consider when you are dealing with a voluminous telephone call or text message situation is to summarize the important part of the information, because I'm thinking to some cases in the past where the caller text detail was 50 or more pages long, because that's how long the stalking was going on. So it is helpful, and also that caller text detail may capture lots of irrelevant information, right? So to summarize that information, we have the Rules of Evidence 1001 regarding summaries, and this doesn't have to be anything particularly fancy. Really, the crux of these records is how many calls, how many text messages were sent from a particular number the opposing party to your client's phone receiving number within a certain time range. Yeah, courts have been more than happy, in my experience, to accept a summary of that nature. Of course, you have to make sure that you have the underlying data available for the court and for the opposing party to review. That's all I have for that. Thanks. Quick word on blocked calls. I feel like this is also something that maybe I have not been running into quite as much, but to the extent that people are still using blocked calls, there is a workaround. And just to be clear, I do not own any stock in this company, but there's a private company called TrapCall that you have to pay a monthly subscription. I think it's relatively inexpensive. Maybe I think the basic subscription is somewhere around $6 a month. Basically, what TrapCall does is that it reroutes any blocked calls to their own 800 number. And for some reason I don't completely understand, that our telecommunication systems are set up such that you cannot block your number when you call an 800 number or 911. So rerouting it to their own 800 number automatically unmasks it. And then once the number is unmasked, it is then transmitted to the subscriber's account. In my experience, subpoenaing TrapCall is quite easy. Their subpoena compliance department is very responsive. They'll be more than happy to send very official looking records showing those unmasked calls and supplying you with a letter of self-authentication. So yeah, that's a good workaround if your client is being harassed or stalked through blocked calls. So I thought we would also spend a little bit of time talking about the Wiretapping and Electronic Surveillance Control Act that Pennsylvania has. Pennsylvania is a little bit of an outlier in the United States. I don't remember how many other states actually offhand that have the two-party consent rule as it's generally referred to. I think it's just a handful of states, including Pennsylvania. But the general idea here is that if you're going to intercept a communication, whether that's electronic or oral, and we'll get into that distinction a little bit more in a second, that it is illegal, a felony of the third degree, I believe, if the parties to that communication did not consent. And there are some very important exceptions that we're going to be talking about to that rule, but that's sort of the general idea. Now, it's, as far as, well, in my experience, I have not seen a lot of actual prosecutions of people for violating the Wiretapping Act, making an unauthorized intercept of a communication. The way that it seems to generally play a role in cases, certainly in family law cases, is that it's used to exclude evidence, right, as the fruit of the poisonous tree. So if it was illegally obtained evidence, then it's not going to be allowed into evidence in your PFA or custody case. Thanks. So the first thing that you need to do when you're considering wiretapping issues is to figure out whether or not you are dealing with an oral or electronic communication. So is the thing that was intercepted electronic or oral? Intercept is defined very broadly. Any sort of acquisition of the contents of an electronic or oral communication using whatever that would include, if two people are talking face to face, right? So that would be an oral communication. There is no electronic devices being used to mediate the communication between the two individuals. So, okay, now we're talking about oral communication. Now, if I have my cell phone in my pocket and I'm using some sort of app, whatever, and I begin to record that communication, that's going to be considered an interception. So I'm now intercepting an oral communication. Let's see, an example of an electronic interception would be, let's say we're having the same conversation, the two people are having the same conversation, but now it's happening over a telephone. And I, as one of the parties to that communication, begin to record the conversation that's happening over the telephone. Okay, so it's happening on the telephone, it's electronic. My recording using another cell phone or whatever, that would qualify as an interception. So I'm now intercepting an electronic communication. So the way I broke this down, if it's oral, there's an extra step to the analysis. So that will be step number 2. If you could, thanks, Arly. Okay, so with oral communications only, there is this extra little bit of analysis that you have to do, which is to see whether or not the intercepted party to the oral communication had a justified expectation that the communication would not be subject to interception. This is a very fact-specific analysis, by which I mean, if you look at the case law, it's hard to discern any sort of like hard and fast rules about when the expectation is justified under the circumstances. But some factors that you can consider in making your own arguments about whether something should be coming in or maybe out if you're trying to block it, is, where did the communication happen? Was it in a setting that is generally associated with, an expectation of privacy, such as one's home, or somewhere out in public where that expectation of privacy is going to be either a lot less or perhaps non-existent. Did the other person or persons know that they were being recorded and continue to speak? This is something that comes up in some of the cases. And also in some of my own cases. So I can think of some video recordings of oral communications where the opposing party is standing, right in front of the client being video recorded, and you can hear my client, announce to the opposing party that they're being recorded. So you could argue that once they have been informed that they're being recorded, that they no longer have a justified expectation that they're not being recorded because they were told. And at least anything that comes after that announcement should be allowed under the Wiretapping Act. Another factor to consider, if there were third parties present, right? So if there are a bunch of other people around, then what is really the expectation of privacy there? And did the other person make their own recording of the communication? That was something that came up in one of the cases that was sort of a slam dunk, that the person did not have a justified expectation since they were busy making their own recording of the oral communication. Thanks. So again, step 2, that's only for oral communication. Step 3 is for all kinds of communication. So if the participants to the electronic or oral communication did give prior consent to the interception, then of course it's fine. Now there may be some evidentiary questions about whether or not that consent was given or not. So for example, in the example that I just gave about the client, recording a conversation, oral communication conversation going on between herself and the opposing party, if that announcement that she was making the recording wasn't part of the recording, and she says that I announced it just before I began making the recording. Now we have an evidentiary question of, can we show that? Can we convince the judge that the announcement was made or not? If yes, then perhaps that would be sufficient to show consent. But if we have consent, then yes, there's no problem. The interception is legal and the evidence is admissible. If we can't show that there was prior consent given, then all is not necessarily lost. We still have one last possible option to bring the evidence into the case.
Can I ask you a question, Larry?
Yeah, of course.
What if it's kind of an equivocal response to one party announcing I'm recording and the other party says, whatever? What do you do with that?
Oh, Arly. Yeah, I mean, I think that I think I would probably try first to argue not so much consent. I think that I would try, because we're talking about an oral communication, so I think I would try to say that this is not an oral communication the way that it is defined under the Act, because that person did not have a justified expectation that the communication was not being intercepted. And so it doesn't qualify as an oral communication the way that the Act defines it. So it's not even covered by the Act, and therefore the evidence comes in, as opposed to trying to argue that the person had given this sort of, equivocal kind of consent. I think that would be the stronger argument of the two.
Excellent.
Keeping me on my toes.
What I'm here for.
So there is this other exception to the Wiretapping Act that I think is actually slightly less known by practitioners. So I think it's important to point out. So section 5704, parentheses 11, did the intercepting party, so the person making the recording or whatever, have a reasonable suspicion that the intercepted party, so most likely the opposing party, is about to commit, or has committed a crime of violence? And did they have a reason to believe that the evidence of the crime of evidence may be obtained from the interception? And if the answer to this question is yes, then the interception is legal and admissible. And if no, then it's not coming in. So what is a crime of violence? Of course, it is defined by the Act, and it's a relatively lengthy list. Most of these things are what you would sort of expect, I think, to see in a definition of crime of violence. So your murder, manslaughter, and so forth. The two entries here that I'd like to think about a little bit, though, is the intimidation of witness or victim, and retaliation against witness, victim, or party. Arly, if you can move to the next slide, thanks. Right, so intimidation, retaliation. Intimidation is in the criminal context, right? So different kinds of behavior that are, designed to intimidate a witness to interfere with the criminal, with the prosecution of a criminal case. And then retaliation being in the civil context, you know, trying to get somebody essentially not to pursue a civil matter through the use of some kind of retaliatory action. So if I can get this. The reason that I want to highlight this is that I think if you have a client with either a criminal stay away order or a no contact protection from abuse order, I think it arguably any communication from the restrained person, the defendant in that criminal or PFA matter, can create a reasonable suspicion that that opposing party is committing or about to commit the crime of intimidation or retaliation, because they are violating these orders that are meant to protect your client from that defendant. So if we have a reasonable suspicion that one of these crimes is about to be committed, or rather because the communication itself, right, is the suspected crime, it would also stand to reason that it's reasonable to believe that the interception of the communication will obtain evidence of the crime, which is sort of the second prong of this crime of violence exception. And I have made this argument at least once, I think maybe twice successfully in PFA matters. And I was able to bring in interceptions of electronic communications. The example that is most readily comes to mind was a telephone call in violation of a no contact protection from abuse order, where my client basically recorded that call with a separate device. And that would normally be prohibited under the Wiretapping Act. She did not announce or otherwise, you know, obtain the consent of the opposing party in making that telephone call. But the judge did agree with my argument that it fell under the crime of violence exception, and particularly the retaliation part of that definition. And I think I just answered Daniel's question that it was used in a PFA, but I'm not following the chat very clearly, so I'm not sure if I'm answering the right question or not. I did? Okay. Okay, so we're running a little bit tight on time. So we're going to talk a little bit about some ethical considerations. So one question was, can you withhold information about your connection to a legal proceeding to obtain information from a defendant by, for example, creating a fake social media account and friending the opposing party or the opposing party's friends? And the long and short of it is no. That is a misrepresentation, and it violates the rules of professional conduct. What we didn't put on there is that you also can't have a paralegal or some other person that you supervise do that for you, right? You know, at your instructions. That would still be, you know, you violating the rules of professional conduct. And then I guess the caveat here, or the, I don't know, we call it exception exactly, but obviously if the information is publicly available, then sure, you absolutely, that's definitely fair game. Can you share evidence with the prosecutor in a related criminal matter? And I believe the answer is yes, as long as you have the client's informed consent. This is actually one of my favorite things to do because there are lots of sort of benefits that can accrue to your client through the successful prosecution of a related criminal case. You know, obviously you can invoke, you know, the rule of collateral estoppel if somebody has been criminally convicted of simple assault or some other type of crime that obviously is going to satisfy the definition of abuse in a PFA case. And so then you are more or less insured to get a protection order for your client. And then, of course, convictions of certain kinds of crime are also going to be very useful in a custody matter, the 5329 crimes, convictions of those types of crimes. So yeah, just make sure that you are explaining carefully to your client what this means, explain the role of the prosecutor, that the prosecutor is not your attorney. They represent the state, the Commonwealth, not you, so on and so forth. Okay, under 1 minute.
We have just about 1 minute left, and there was a question in the comment about electronic evidence during COVID, and what to do about that, which I think is a whole other webinar. And I also think that Larry and I are probably not the people to talk about that, because Philadelphia is light years behind the rest of the counties and just like shut down and hasn't done anything. But if anybody wants to send in some chat comments about tips and tricks they've been successful with during the pandemic, I'm sure that would be really appreciated.
And this is Kelly. While people are sending in any questions or comments they have, I'm going to launch the second of the CLE chat box questions. Please respond, and I will leave it up for a minute. Thank you.
Great. Well, while you answer those questions, that's all that we have prepared today. Thank you for attending. If you have any questions, please reach out to Larry or I, and Kelly will be distributing the materials.
Absolutely. Yeah, and happy Juneteenth tomorrow.
Thank you so much for being here with us, Arly and Larry. We really appreciate it.
Thank you.
Have a great day.